Hello friends, welcome to Learning Unlimited. You all are requested to like my video and subscribe my channel. Today we are going to discuss on the Interstate Migrant Workmen Regulation of Employment and Condition of Services Act 1979. In that we will going to discuss applicability of the act, clarification on the act, right and role of the principal employer, role of the contractor, right of interstate worker, penalty provisions, and additionally, we are also going to discuss merits and demerits of the Act. Okay, friends, now let's move on. First of all, applicability of the Act. Every establishment in which five or more interstate migrant workers, whether or not in addition to other workmen, are employed or who were employed on any day of the preceding 12 months. Every contractor who employs or who employed five or more interstate migrant workmen, whether or not in addition to other workmen on any day of the preceding 12 months. Now, we will going to discuss about some more detailed clarification on the interstate migrant worker. What is the definition of interstate migrant workman? As per the Act, Section 2, subsection E of the Interstate Migrant Workmen Regulation of Employment and Condition of Services Act 1979, the interstate migrant workman means any person who is recruited by or through a contractor in one state under an arrangement or other arrangement for employment in an establishment in another state, whether with or without the knowledge of the principal employer in relation to such establishment. This basically applies to contractors who recruit personnel from one state and engage such personnel in other states through him in any other establishment. It does not apply to your establishment if you are, as an employer, recruit personnel through an advertisement conducting interview at your premises. Also, not to those who have regional offices, recruit and transfer to the other states. Further, it is not applicable to a person of other state, walk in, apply, have proof of residence of state of the employer and employment. Now, what is role of principal employer in this? Registration of all principal employer who employs or employed directly or indirectly five or more interstate migrant workmen on any day preceding of 12 months. Maintain the register indicating the detail of interstate workers and make available to scrutiny by the statutory authorities. Every principal employer shall nominate a representative duly authorized by him to be present at the time of disbursement of the wages by the contractor. It shall be the duty of such a representative to certify the amounts paid as wages in such manner and as may be prescribed. Principal employer shall be liable to bear the wages and other benefits to interstate workers in case of failure by contractor to effect the same. Liable for the prescribed punishment for violation committed under this Act. In case of any employment injury or fatal accident, ensure the same is informed to authorities of state concerned and to the kins of the deceased through the contractor. Now, we will understand about the of contractors. Registration of all contractors who employs or employed five or more interstate migrant workers on any day of the preceding 12 months. Furnish the detail of workmen periodically in such a form as prescribed by the state government. Maintain the registers indicating the detail of my interstate workers. Make available for scrutiny by the statutory authorities. Issue a passbook affixed with a passport size photograph of the workman indicating the name and the place of the establishment where the worker is employed, the period of employment, rate of wages, etc. to every interstate migrant workman. Reporting by the contractor the incidence of fatal accident or serious injury of such a workman to the specified authorities of both the states and also the next of kin of the workman. Liable for the prescribed punishment for violation committed under What are the rights of interstate workers? Yes. In addition to the general labor laws applicable to all workers, the interstate workers are entitled with equal and better wages for the similar nature and duration of work applicable for the local workmen or stipulated minimum wages under the Minimum Wages Act 1948, whichever is more. Displacement allowance 50 percentage of the monthly wages or rupees 75 whichever is higher at the time of recruitment. As per section 15, home journey allowance is also to be given, including payment of wages during the period of journey. Suitable residential accommodation and medical facilities free of charge on mandatory basis. Termination of employment after the contract period without any liability. Right to lodge complaint with the authorities within 3 months of any incident, accident, etc. We'll go ahead and look about the penalty provisions. Whoever obstructs an inspector for making any inspection, examination, inquiry, or investigation shall be liable with imprisonment for a term which may extend to 2 years, or with fine which may extend to rupees 2000, or with both. Contravention of any provision regarding employment of interstate migrant workmen shall be punishable with imprisonment for a term which may extend to 1 year, or with fine which may extend to rupees 1000, or with both. Proceeding against company director and partner, or manager, secretary, or other officer shall be guilty of that. Now, very most important thing about this act is merits and demerits. This is based on the very practical experience. I'll share with you the what are the merits and demerits of the act. Merits are registration and compliance of the act shall protect company from penalty and proceedings. It is easy migration of non-local without legal barriers. One more merit is less absenteeism amongst non-local workmen. It is benefit for the industry. Now, productivity and stability will be added advantage amongst non-local and migrants. But talking about the demerits, first is lengthy process of registration. Second is shall have to maintain 85% of local workforce. Third is authorities practically may grant registration to practical principal employer but does not provide registration to contractors. Fourth is reluctant to understand the local customs. Yes, the migrant workers are reluctant to understand local customs. Fifth is compulsory to have police verification. It requires to avoid notorious characters. And last, sixth is need to take prior approval of other states' employment exchange and ALC before migration. Taking approval is not cost effective. Okay, friends, I hope you understand all this very detailed analysis of this act. Thank you. And at the last, I request everyone to like the video and subscribe my channel.